The last year and a half, we had a phenomenal frenzy across the European Union through the revision of directives. Many instances, the European institutions come back and forth to industry, academia, practitioners, and also stakeholders in relation to how the directives should be modernized, how the directives should be reformed. Make sure that you also remember that the directives are relatively new. They're less than 6 years since they came into force during the last revision of the public sector directive and also the utility directive, which consolidated procurement regulation in both sectors. The themes that we have for review are the following. These are what the European Commission, the European Parliament, and the Council are putting forward for discussion. The first is the notion of in-house arrangements. The ability for local authority, public sector authorities to procure in-house, utilize their in-house teams. The second is the sub-dimensional procurement. What happens to procurement contracts that fall below certain thresholds? Do the directives apply? Or if not, what happens in terms of transparency and objectivity and treaty provisions that are fundamental to the functioning of the internal market? Another theme is the non-priority service contracts. The public sector directive provides for certain categories, the non-priority services, that they are sui generis regulated. They do not fall under the full remit and the full thrust of public procurement rules, and they have a very swift and very short-track portion of the procurement process. Last but not least, one of the most painful exercises that the European institutions have witnessed is the service concessions. What we do with them? Concessions are the most important element of engaging the private sector as a stakeholder and as a deliverer of public services. However, time and again, European institutions did not want to regulate service concessions as public contracts. They left them outside the procurement directives. Currently, there's a directive. Currently, there is a huge debate about if service concessions should be included into the system of regulating public procurement. The last painful exercise, and I said that with a little imagination, if I may, is the use of competitive dialogue. The most celebrated option of the new procurement directives in 2006 onwards was the introduction of that specific award procedure. However, the industry did not like it to the extent that the European institutions wanted the industry to like it, for a number of reasons. Basically, because it creates a cumbersome process of selection and qualification, and mostly because the industry is very susceptible to protecting their own intellectual property rights, and they do not want to share any competitive solution with other partners into the dialogue process for the procurement of public contracts. I'm sure you're aware that as practitioners, as specialists in European policy and European law, as specific practitioners in sectoral application of procurement, that the most important element of the procurement process is the modernization. We are in a very crucial point when the European institutions think that procurement could be an industrial policy instrument. That means that they can be used, the rules for procurement could be used for not only promoting the small and medium-sized enterprise, not only for promoting social cohesion, not only for promoting specific sectoral policies such as employment policy or green policies such as protection of the environment, but also for providing a platform for delivering public services. There's a new acquis, there's a new legislation coming from Brussels in relation to public services and services of general economic interest. Health services are part of that. Transport services are part of that. Waste disposal and water management are part of that debate. So the big question for the European institutions and us as also the custodians of public procurement is how the delivery of public services could interface with the public procurement rules. Do we need a specific flexibility? Do we need functionality in the rules? Do we need the authorities across the European Union to play a more active and more proactive role in adapting the rules towards their own requirements? The latest that we have from Brussels is that we're expecting quite soon, probably within the next quarter of the calendar year, the final draft of the directives and also the provisions of the services, the Concession Services Directive, that we could see some improvements towards the new acquis. There is also a tremendous amount of anticipation from other partners across the Atlantic, mainly from the United States and North American partners, on the World Procurement Organization, the Government Procurement Agreement under the World Trade Organization, to see how that regime will interface with access to markets in relation to their contracts, respectively in their own markets and also in relation to the European Union markets. The most important point that we'd like to see today in this conference is to what extent the industry, to what extent sectoral industries see the procurement rules as an obstacle to advance their own anticipations of economic growth into the market, and also to what degree they see that as a necessary ingredient for the functioning of the European market. I say that with one thing in mind, that procurement also rests on the pedestal of legitimacy. We have a new directive in relation to remedies. There's a tremendous amount of intellect gone into the remedies directive that allow aggrieved contractors across the European Union to contest public authorities' decision in relation to the award of public contracts. There are new remedies in relation to the inapplicability of directives or the inapplicability of the award procedures for certain contracts as well. And damages as a necessary remedy for a wrongful award of contracts. That should be put into the equation as well to see how well, how balanced the new regime is. I'd like also to ask the audience later on, perhaps at the end of the panel sessions, as to how they feel that the procurement rules should serve the industry for the future, this specific decade, the decade for the need of economic growth. There is a Brussels 2020 strategy. There's a lot of emphasis and there's a lot of remit put into that specific strategy for economic growth. And internal market, the DG for internal market, places tremendous hope into linking procurement in growth strategies, specifically in relation to certain industries. Industrial policy becomes a serious objective of the European Union. So this is the broad idea. I wanted to paint you the picture on the broad idea, what's happening at the moment, what are the issues, what are the themes, and how these themes can be translated into specific sectoral areas.